Welcome back to 2A News Now, and I really do appreciate you taking your time tuning into my video. Real quick, if you guys could do me a large favor. The channel is about 1,000 subscribers short of 60,000 subscribers. So if you guys would just take a couple of seconds of your time and like, share, and subscribe and hit those post notifications, I really would appreciate it. A federal judge has ruled that a lifetime ban for a nonviolent misdemeanor offense doesn't disqualify you from exercising your Second Amendment rights. In a case very reminiscent of Range versus Garland, in which the Third Circuit Court of Appeals ruled that Brian Range's conviction for lying about his income on a food stamp application decades ago should not have resulted in a lifetime prohibition for keeping and bearing arms. A federal judge in Pennsylvania has ruled that a man's 2005 DUI arrest and conviction on misdemeanor charges cannot disqualify him from exercising his Second Amendment rights. Though Edward Williams was convicted of a misdemeanor offense, it was also a crime punishable by up to 5 years in prison. But Williams didn't serve any time behind bars. However, instead, he was sentenced to 90 days of house arrest in order to receive treatment for alcohol and drug abuse, since the potential sentence was more than a year in prison. However, the misdemeanor conviction meant that Williams was considered a prohibited person going forward, and he was no longer allowed to possess or purchase a firearm. Williams first tried to challenge the statute in question in 2017, but was denied, and later applied for a rehearing after the Supreme Court issued its decision in Bruin last year. This time around in a case argued by 2A attorney Joshua Prince and supported by the Firearms Policy Coalition, U.S. District Judge John M. Young applied the court's text, history, and tradition test to the Williams case, as well as a third court's decision in Range versus Garland, and found that Williams cannot be denied access to his right to keep and bear arms as a result of a nonviolent misdemeanor conviction, even if it was punishable by years behind bars. Judge Young noted that while he remains quite concerned about the prospect of granting access to firearms to persons who have demonstrably abused alcohol, he remains convinced that the general dangerousness of drunk driving and combining firearm use and alcohol consumption establishes that DUIs must therefore be considered sufficiently analogous to historical examples of dangerous conduct that have previously served as grounds for disarmament. The judge acknowledged that the government's citing of laws that prohibited the carrying of firearms while intoxicated, but argued that none of those regulations allude to disarmament lasting beyond the individual state of intoxication, and none provided for permanent disarmament, as Section 922G1 does. I think we all agree that drunk driving is a very serious concern, and not something that should be easily dismissed. But the fact is that Williams wasn't barred forever from getting behind the wheel of a vehicle because of his misdemeanor conviction. He can obtain a driver's license and purchase a vehicle, despite his DUI conviction that is now nearly 20 years old, but he can't legally purchase or possess a firearm? That's a punishment that doesn't fit the crime as far as I'm concerned. Surely the Department of Justice will appeal this case to the Third Circuit. But given their decision in Range, it's unlikely that Merrick Garland is going to get the response he's looking for from the appellate court. By the time Williams versus Garland gets to SCOTUS, the justices will have had a chance to weigh in on Brian Range's case. And if the court does adopt a dangerous standard of depriving individuals of their Second Amendment rights in Rami, then both Range and Williams will have an excellent chance of having the lower court's decisions in their favor approved by the majority of Supreme Court justices as well. It's just another case of the Department of Justice trying to trample on someone's Second Amendment rights. The man was charged and convicted of a DUI misdemeanor crime. He wasn't labeled a felon. The judge didn't take away his driving privileges or take away his license, but they decided to take away his Second Amendment rights? What sense does that make? As always, I would really like to hear your thoughts about today's video in the comment section down below. And like I mentioned at the starting of the video, we're getting really close to 60,000 subscribers. And I hope to reach that before the first of the year. If you guys could please help the channel out and help it grow by liking, sharing, and subscribing and hitting those post notifications. And I invite everybody back to watch my next video.